Ready? Exercise number 19. Start. While considering an appeal filed by a UPSC candidate against rejection of his request for a scribe, the bench noted that under Section 20, every government establishment is required to provide reasonable accommodation and a conducive environment to employees with disability. Stop, next para. The principle of reasonable accommodation captures the positive obligation of the state and private parties to provide additional support to persons with disabilities to facilitate their full and effective participation in society. The concept of reasonable accommodation is developed in section H below. For the present, suffix it to say that for a person with disability, the constitutionally guaranteed fundamental rights to equality, the six freedoms, and the right to life under Article 21 will ring hollow if they are not given this additional support that helps make these rights real and meaningful for them. Reasonable accommodation is the instrumentality or an obligation as a society to enable the disabled to enjoy the constitutional guarantee of equality and non-discrimination. The bench observed in the judgment. Stop, next para. In the specific context of disability, the principle of reasonable accommodation postulates that the conditions which exclude the disabled from full and effective participation as equal members of society have to give way to an accommodative society which accepts difference, respects their needs, and facilitates the creation of an environment in which the societal barriers to disability are progressively answered. Accommodation implies a positive obligation to create conditions conducive to the growth and fulfillment of the disabled in every aspect of their existence, whether as students, members of the workplace, participants in governance, or on a personal plane. In realizing the fulfilling privacies of family life, the accommodation which the law mandates is reasonable because it has to be tailored to the requirements of each condition of disability. The exceptions which every disabled person has are unique to the nature of the disability and the character of the impediments which are encountered as its consequence. Stop, next para. For instance, for a visually impaired person, the reasonable accommodation she requires might consist of screen magnification software or a screen reader which can speak out the content on a computer screen in a mechanical voice. It might also consist of content being made available in Braille and a sighted assistant. In the same way, for someone with a hearing impairment, reasonable accommodation could consist of speech to text converters, access to sign language interpreters, sound amplification systems, rooms in which echo is eliminated, and lip reading is possible. Similarly, for a person with dyslexia, reasonable accommodation could consist of access to computer programs suited to meet their needs and compensatory time. Stop. Next para. The analysis by this court in the portion excerpted above begs the question, especially the relevant question under the reasonable accommodation analysis is not whether complications will be caused by the grant of a reasonable accommodation. By definition, reasonable accommodation demands departure from the status quo and hence avoidable complications are inevitable. The relevant question is whether such accommodations would give rise to a disproportionate or undue burden. The two tests are entirely different. As we have noted previously, the cornerstone of the reasonable accommodation principle is making adjustments that enable a disabled person to effectively counter the barriers posed by their disability. Full stop. Thank you very much.